Officer, respected Attorney General Mr. R. Venkatramani Garu, and organizers.
Sir, the camera. Camera.
Very
Sir.
good morning.
Ashgar.
I am happy to associate
Yes, ma'am.
Damodar
Yes, yes.
Sanjivaya National University with
Yes,
Justice
yes, it's
Siddhar
on.
Karna Memorial National Symposium on the topic without fear or favor, reimagining perspectives on an independent Indian judiciary in the digital and globalized world. As we know, India is a democratic country, and we know the constitutional values, morality for which the Indian society dedicated, and for the last more than 75 years, the functioning of the constitutional system in India proves that India is a successful democratic country. And as we know, the three major organs of any political state, legislature, executive and judiciary, under the separation of powers document, when we fought, the Indian society fought against the colonial rulers and ultimately got independence, we decided to have our own constitution, and for that purpose we have consulted various other constitutional experiences. 150 years more American constitutional experience is with our constitutional matters and British constitutional system and various other constitutions like Irish and other constitutions while framing the Indian constitution. At the time of the printing of the Indian constitution, we committed to the rule of law, and particularly the functioning of the Indian constitution mainly based upon the legislature and executive, and the judicial review of legislative action and legislative action and executive action are being held by the then judiciary. What is the constitution is no doubt in the text is to be accepted, but what really the constitution is, how the judiciary understands the constitution is only the real constitution. If we are aware about the functioning of the Indian constitution, in the first 50s, the Indian Supreme Court has been dominated by the Oxbridge culture trained judges who gave more importance to right to property, and in order to dilute the right to property as a sacrosanct values, the legislature brought various constitutional amendments. First constitutional amendment itself brought particularly the 9th schedule was created and article 31A, B were created, and particularly 60s also the Indian judiciary gave more importance to right to property, and various litigations were there reeling around right to property, whether it is bank nationalization case or whether abolition of privy purses or introducing various socio-economic reforms by the parliament. And particularly in 1970s, when the then government under the leadership of Madam Gandhi brought various constitutional amendments after Madam Gandhi came to power with 2/3 thumping majority in the midterm elections, her government brought various constitutional amendments, particularly brought 31C, which gives importance, particularly Directive Principles 39B and C, prevention of concentration of economic power and material resources redistribution. In order to implement this particular directive, if any legislation is brought, that legislation cannot be challenged in any court in the spirit of that Article 31C. This was challenged in Keshwananda Bharati versus State of Kerala, where 13 judges had. Here, Justice H.R. Khanna played an important role. Even though 7 judges accepted the basic features of the constitution, so subject to the basic features, Parliament can amend any part of the constitution. But regarding the constitutional validity of Article 31C comes, 6 judges approved Article 31C, which promotes any legislation in order to implement 39B and C in toto, including the exclusion of judicial review. 6 judges in toto invalidated that particular thing. It is Justice H.R. Khanna who accepted the first part with the first 6 judges and second part with the second 6 judges, so that that's why sometimes it is commented regarding the constitutional validity of 31C, which was newly added to the constitution, is only single man judgment. The single man judgment is H.R. Khanna's judgment regarding the validity of 31C. He accepted any legislation can be brought in order to implement Article 39B and C of Directive Principles of State Policy, but subjected to the judicial review. Judicial review of the legislation is to be taken up by the judiciary to validate or invalidate of that particular legislation, whether it is within the spirit of that particular legislation or not. That aspect is there, and moreover, the contribution of Justice H.R. Khanna regarding the right to property was concerned in Indira Nehru Gandhi versus Rajanarayan, popularly known as elections case. Justice H.R. Khanna expressed his opinion that he did not consider right to property as that much sacrosanct value. So, taking the advantage of Justice H.R. Khanna's opinion, the then Janata Party government brought 44th constitutional amendment to remove right to property from Article 31 and Article 39 clause F, so that these two were removed from fundamental right chapter and they were made mere constitutional rights under Article 300A. This is the contribution of Justice H.R. Khanna regarding the understanding of right to property. Another aspect regarding to right to liberty, as I already just mentioned, in 1950s and 1960s, that much recognition was not given to the right to liberty. That's why A.K. Gopalan to particularly R.C. Koppar. Meanwhile, Justice Prakasa Rao might have been giving his judgments through by way of minority judgments and correcting and other things where right to liberty was given that much importance. It is here Justice H.R. Khanna first time understood the value of human rights jurisprudence, particularly during emergency, when under Article 352, when emergency was proclaimed, the immediate effect of national emergency is suspension of fundamental rights under Article 358. If President of India further intends, he can suspend Article 19 is suspended under Article 358. Under Article 359, if President further intends, he can suspend the other fundamental rights. During the national emergency proclaimed in 1976, the President of India suspended all the fundamental rights, where various high courts, when various writ petitions were filed in various high courts simply denied the issue of writs on the ground that they were exercising the power of the writ jurisdiction. Whereas all these writs came to the Supreme Court of India, ADM Jabalpur versus Shavkan Shukla, popularly known as habeas corpus case. Out of 5 judges, 4 judges including Justice Chandrachud, Y.V. Chandrachud, declared that when national emergency was there, suspension of fundamental rights was there, and including the writ jurisdiction was suspended. But it was Justice H.R. Khanna boldly declared whether there is a constitution or not in a particular country, it is immaterial. No sooner a human being is born, he acquires inalienable sacrosanct values. So those cannot be forfeited or taken away by any political state. Those natural rights can be attached to a human being on his birth. Those can be naturally eroded on the death. In between life and death, birth and death, nobody should interfere in the human rights of that particular individual. That bold judgment, minority judgment, became the majority judgment in post-emergency era in the form of Maneka Gandhi versus Union of India. So the minority judgment, the opinions of Justice H.R. Khanna in 1970s now are the basic structures for the Indian constitutional rule of law administrative system. So basing upon his opinions in 1970s, in post-Maneka scenario, the Indian Supreme Court protected the rights of the people. That's why Justice H.R. Khanna should be remembered forever. As long as there is Indian democracy, as long as there is rule of law, as long as there is constitutional system in a particular democratic country like India, Justice H.R. Khanna should be forever remembered. So that's why the people like even Justice, here I have to mention one of my personal experiences when I attended a workshop in Delhi in 1993 where Justice Krishna attended that workshop for 5 days continuously. During that particular workshop, Justice Krishna revealed his personal experience with Madam Gandhi. Madam Gandhi invited Justice Krishna for breakfast just to get the solid support of Justice Krishna for constituting 15 judges bench under Justice M.H. Beg just to review Kesavananda Bharati decision. Then Justice Krishna suggested Madam Gandhi, in a democratic country like India, basic structure doctrine should be there to protect and promote Indian democracy. So don't make any attempt to dilute the spirit of basic structure. Accepting and agreeing the opinion of Justice Krishna, Madam Gandhi dropped the idea to insist the judiciary. In those days, we all know Madam Gandhi government, executive ridden parliament, always demanded that there should be committed judiciary. There should not be independence of judiciary. So committed judiciary was expected by the executive, but Justice H.R. Khanna and similar public spirited and constitutionally spirited judges protected the constitutional system forever. And we all know Madam Gandhi government first time after Kesavananda Bharati deviated from the established norm of appointing senior most judges, Chief Justice of India. So first 3 judges were superseded. Justice Hegde, Justice Shalad, Justice Grover were superseded. The 4th senior judge, Justice A.N. Ray, was appointed. So second time, when Justice H.R. Khanna had the opportunity to be elevated as Chief Justice of India, Madam Gandhi government superseded and the next senior most Justice M.H. Beg was appointed. In protest, Justice H.R. Khanna resigned. And more interestingly, Justice H.R. Khanna, when Morarji Desai government was toppled and Charan Singh government was formed, on the invitation of Charan Singh, Justice H.R. Khanna joined as law minister in Charan Singh cabinet. But when the press objected, some comments were made in the press that what towering personality like Justice H.R. Khanna accepted the minister in a Charan Singh government, a defected government. Immediately within 3 days, Justice H.R. Khanna resigned from that minister. That is the integrity of Justice H.R. Khanna, who should be imbibed and followed and nurtured by the younger generations of the Indian nation to get the Indian, to support and promote the Indian democracy forever. And Justice Khanna is also the Law Commission chairman. As a Law Commission chairman, he brought several reforms to the Indian legal system. That's why Khanna's ideology, Khanna's opinion for the strong human rights jurisprudence was further strengthened by the next coming judges like Justice V.R. Krishna, Justice Chennapareddy, Justice Bhagavati, Justice Kuladip Singh, and Justice D.A. Desai, and many more others. For all those people, Justice Khanna paved the way to show that how the democratic values can be strengthened through the Indian constitutional system. that is proven fact. The Indian history can remember Justice H.R. Khanna forever, and moreover, if you observe the second term tenure of Madam Gandhi, she interfered, her government interfered more and more in the judicial functioning, and the government demanded committed judiciary in the first phase. But when Madam Gandhi came second time, there was no such important incident where Madam Gandhi interfered in the judicial independence nature. So that can be understood how Justice H.R. Khanna, like-minded people, how they strengthen the constitutional values, democratic values in Indian democracy. So even the earlier autocratic practitioners of the functioning of authorities changed their minds. They wanted to strengthen the Indian democracy. So because now we have a successful Indian democracy in 2026, this definitely the success of Indian democracy owes to the people like Justice H.R. Khanna. I deem it a privilege to associate my university with this prestigious 5th Justice H.R. Khanna Memorial National Symposium in Digital World in Artificial Intelligence Influenced Technology. We have also promote and protect independence of judiciary, of course regarding appointment of judges, regarding the relation between judges and executive. All these are the sensitive issues where the public is watching. So public transparency, accountability, all these are to be further strengthened. In order to strengthen the Indian democracy, I welcome Justice Joyamala Bagachi sir and Venkatramani sir to this prestigious 5th Justice H.R. Khanna Memorial National Symposium. I welcome all the participants, student friends, for this important, prestigious 5th Justice H.R. Khanna Memorial National Symposium. Thank you very much, sir, for giving me this.